All right, we're going to talk about impeachment for the most part today, maybe a little on rehabilitation. But before we get into that, I wanted to talk a little bit about cross-examination in general. I saw some of the performances on Monday, and because impeachment is a particularized type of cross-examination, wherein it's even more important that you adhere to the fundamentals of sound cross-examination technique, that we revisit, just at least generally, some things you need to think about when you're doing cross-examination. The primary one of which is to not ask open-ended questions, non-leading questions. And in the main lecture on cross-examination, I'm not sure if we made sufficient indication as to why that is necessary. But the short answer to that is if you ask an open-ended question, you're giving the hostile witness, and especially if it's an opposing party, and a very important hostile witness, the opportunity to explain their behavior. What do you think they're going to do if given that opportunity? They're going to put it in the most favorable light possible. So if you ask Parker on cross-examination, what did you have, or were you drinking at lunch? What do you think he's going to say? He's going to say what I heard. Yes, but I only had a wine spritzer. As opposed to, you were drinking at lunch, weren't you? In fact, you had 2 martinis at this lunch, didn't you? No, I only had a wine spritzer. Okay. You remember writing an email when you came back to the office after that lunch? Let me show you the email that you wrote, right? And that email was referring to the martini in a sarcastic way. Had a bad day, but nothing that a martini won't solve, or something to that effect. Okay, that's an example of impeachment, but impeachment using this leading question technique. In other words, there is nothing inquisitorial about cross-examination. You are not asking questions. Yeah, theoretically you're asking questions because it's supposed to be a question. But you're not asking questions. It's declarative. You're making statements. You're actually testifying what you want the jury to hear. And yeah, you're going to put a question at the end of it because you're supposed to ask a question, but it's a declarative statement where all you want is an affirmation of what you are saying. All you want that witness to do is agree with what the story you are telling through your questions. You were drinking, you had 2 martinis. Or what you did when you got in your car. I heard people asking, cross-examining Parker and asking him, what did you do when you first got into your car? What do you think he's going to say? Oh, I was uber prudent, right? I took my time. I checked my rear view. I checked my side view. I visually confirmed that there was no traffic. I slowly eased out. And then, bam! This guy comes flying into me. Does that help you? As opposed to, when you got into your car, you turned the air conditioning off, didn't you? You had the radio blasting, didn't you? That made it difficult for you to hear, didn't it? You're saying, you're painting a picture, you're telling the story through your questions, which is really a statement with a question tacked on at the end. So I got the sense that there still may be some uncertainty as to how to phrase a leading question. One simple thing to remind you of that technique is to simply put the question at the end of whatever it is you want to say. Now I know Professor Cialino told you in cross-examination and how to frame a leading question that you don't even have to put a question at the end. That the way you ask the question, the inflection, automatically signals that it is a question. You had 2 martinis, so you don't even have to say, did you? But to train yourself to discipline yourself to always ask a leading question on cross. Just think about that if you draw a blank. Well, all I gotta do is put the query at the end of whatever statement it is that I'm making. Okay? Now, maybe we should have emphasized that more on cross-examination, the actual question, the structuring of the question. What do we mean by leading versus non-leading? But that's critically important. It's even more important in impeachment, which is a form of cross-examination, right? Because impeachment is a golden opportunity. Why? Because it cuts to credibility, and trials frequently turn on credibility, especially of material witnesses. So if you can show, particularly a party witness, is being untruthful and undermine their credibility, that could be a pivotal moment in the trial. In fact, it could lead to your winning the case. So when you have an impeachable moment, you've got to make the most of it, and you've got to do it right, and you've got to do it effectively. And so you can't really do it without leading questions properly. I don't think. It would be exceedingly difficult, if not impossible. So that's why I'm reiterating the importance on cross-examination. Also, just to give you a chance to retool your cross-examination preparation for the trial, and make these adjustments so that you're asking nothing but leading questions. There shouldn't be any, did you do such and such, or how is it that, or explain. If you're using the word explain on cross-examination, something's terribly wrong, right? So, and then another sort of, and this is a hard thing, especially for novice lawyers to discipline themselves against, is this sort of freewheeling cross-examination, just all over the place, feeling you have to touch every spot on the map of the direct examination. And it should be surgical. It's a commando strike. It's not the invasion of Normandy. You go in, you come out, get what you need, you know what is going to work, because you've done your preparation. If you've got impeachable material, you've got it at the ready. You're not going to always get the big smoking gun, the big Perry Mason aha moment on cross-examination. It's usually, a collection of effective but material strikes on the substance of the direct testimony and or the credibility of the witness. Be judicious in what you attack, and be precise and sound in how you attack it, i.e. those leading questions. All right, so impeachment, an impeachable moment. When does that come up? Well, when the witness is being untruthful. They've said something that is untrue, and you know it's untrue because you have a contradictory piece of information coming from that very witness that said something completely opposite to what they just testified to, right? Or you have evidence that suggests that they are biased or prejudiced or have a corrupt motive in giving the testimony that they're giving. Or they're just generally untrustworthy because they've been convicted of a felony, or they've been convicted of a misdemeanor or a felony that goes to their character for truthfulness. Or they did some other prior bad act, but ultimately is to attack their credibility as a witness. And there are different bases for impeachment, as you'll see that I have up here. We're going to go through all of them for the most part. So each one of these requires sort of a different, depending upon the subject matter, a different approach, right? Just because of the nature of the impeachable information. Now, a lot of this is premised on the rules of evidence. And and I don't want to get too ahead of you on what some of you may be studying currently in evidence, but I'm going to talk about some federal rules that you may or may not have encountered. By the way, have you all gotten to impeachment in evidence? Have you gotten to rules 609, 613?
That's tomorrow night.
That's tomorrow night? Timing is everything, huh? Okay, well, maybe this will be a little intro prelude to impeachment under the federal rules. So let's talk about, just generally speaking, the different types of impeachment. Probably the one that you are going to encounter most often in practice, and probably in this case is going to fall under a prior inconsistent statement, right? So that means the witness is testifying about something, and you hear it, and because you were thoroughly prepared and you took depositions, or you know all the facts in the case, you know that's not right. It could be something as simple as, you know, the plaintiff had the red light, right? And that's what he said on direct examination. But you know, in his deposition, he said the plaintiff had the green light, right? That's a black and white kind of clear case of a prior inconsistent statement. But prior inconsistent statements come in different forms. Some are written statements. It may indeed be an email. Let's say the email that Mr. Parker wrote when he got back to the office, right? You can do your whole cross-examination of Mr. Parker just from that email. There's so much, it's so rich for you plaintiffs to cross-examine. You don't really need much else. I'm not going to say any more about that because I want you all to find your impeachable moment in the materials when you do your performances. So it could be a written statement, it could be an email, it could be a memo that they wrote in the office, it could be a letter, it could be any written statement where this witness said something that's contrary to what they said on the stand, right? But it could be an oral statement. They could have told an insurance investigator something that is the direct opposite of what they said on the stand. So that would be a different form of a prior inconsistent statement. The techniques for all of these inconsistent statements are going to be the same, regardless of which of these 5 forms the inconsistent statement is. It could be, and this one is very common, a deposition that the witness gave, and in that deposition you asked him the same question that you asked in that trial, or he was asked on direct examination a question which is the same question you asked him in his deposition, and he gave completely different answers. And there's impeachment by omissions. Maybe, it's for example, a police officer taking down a report of an accident scene, and he says something on the stand that's not in the accident report that he gave. Let's say the officer who responded to the scene said, "Yeah, I could smell alcohol in Mr. Parker's breath." Well, you impeach him with his police report, and you ask him, after you laid the requisite foundation, where is it in this police report that you mentioned anything about alcohol, the smell of alcohol? Or, alternatively, there's nothing in this report, is there? No mention whatsoever about the smell of alcohol. Whatever way you do. That's an example of an impeachment by omission. Okay? We'll go through examples of each of these more thoroughly in a minute. And then there's bias, corrupt motive, prejudice, interest, prior criminal convictions, and prior bad acts. Those are the main ones and the ones that we're going to talk about tonight. But a couple of general considerations. This way it gets a little bit evidence, the rules of evidence come into play. One is, have you all covered the collateral facts rule in evidence yet? No, I take that as a no. So, okay, what that rule provides is that if the impeaching material is only pertinent to the issue of credibility, right? that fact is collateral. It's collateral to the issues in the case. Okay? So that means even if the witness untruthfully denies that fact, you have to accept the answer, and you can't put on any extrinsic evidence to prove that he's lying, right? Now, on the other hand, if the material, if the impeaching fact, I should say, so no extrinsic evidence is allowed if the witness is asked on cross-examination and admits the truth of the impeaching material. Yeah. In your deposition, you said that the Cadillac had the green light, didn't you? As opposed to saying he had the red light at trial, right? If the witness says, yeah, you're right, your impeachment is over. No, you cannot at that point go into any extrinsic evidence to prove that they are being untruthful. If the witness, however, denies the fact, or they're getting, they're being equivocal on it, they're, I'm not quite sure, they're just kind of like being intentionally elusive, or even unintentionally elusive, then whether you can admit extrinsic evidence to prove that they are lying or to impeach them will depend upon whether or not the matter is collateral or non-collateral, right? If it's collateral, you can't, as we said earlier. So those are just two considerations at the outset that I wanted to just generally, frame this discussion around. That may make more sense to you when you actually cover this in evidence tomorrow. Okay, so let's talk about prior inconsistent statements in general. You see there, as we said, there are different forms of them. But if the witness testifies to one fact in court and they've made a inconsistent either oral or written statement on a prior occasion, that prior inconsistent statement can be used for impeachment. All right? And as I said, it could be oral, it could be written, it could be contained in the deposition, it could be contained in the transcript of testimony that they've given previously. Doesn't matter. But that's what prior inconsistent statements involve. You with me on that? Mm-hmm. So somewhere and that's why, again, it underscores the importance of preparation and proper discovery and your investigation of the facts of the case, because that's where you're going to develop the information that potentially will contain impeachable ammunition, so that you know what this witness should be testifying to. And when they stray from the universe of facts that you've collected, then you can impeach them with it. The primary one of which is the deposition. Why do you take the deposition? To lock in their testimony, right? So you know what the witness is supposed to testify to on direct and what you are going to be able to just generally cross-examine them on when it's your turn to cross-examine them. So, back to the rules of evidence, and this is where it can get a little bit sticky. Have you ever covered Queen Caroline's case, or the Queen's Rule, as it were? You haven't, probably because you haven't gotten to prior inconsistent statements yet in evidence, right? Okay, here we go again. Let me see if I can tell you what I'm getting at here, because this is all presented from a pragmatic standpoint, not a doctrinal. I don't want to turn this class into a rules of evidence class, but from a tactical standpoint. Okay, at common law, you have to lay a foundation before you impeach a witness with a prior inconsistent statement. And that, when you're dealing with a writing, that requirement of laying the foundation comes from a case called the rule in Queen Caroline's case, or the Queen's Rule. And that just requires a lawyer to show a witness the writing, the prior inconsistent written statement, lay a foundation as to the time, place, and circumstances of its creation. And you have to do that before you question the witness about it. right? So that is a more elongated, common law, elongated way of impeaching by a prior inconsistent statement. So whenever you have to impeach, or if you ever impeach, using that elongated, laying the foundation. And why do we have to lay a foundation? To show that the information is reliable. The prior inconsistent statement is reliable, right? A deposition is given under oath, given maybe with the presence of counsel for the deponent. The deponent takes, swears to tell the truth, the same oath they took in the courtroom, right? They gave their testimony. They were given an opportunity to review their testimony for accuracy. They reviewed the transcript. They signed the transcript. This is the transcript, right? That's a lot of information now. So, you know, if you have to lay that kind of foundation, or if you go through all of those foundational steps, not all of that may be necessary, but if you do all that, you run the risk of the jury forgetting what the hell you're doing to begin with, why you embarked on this path, and what are you up to, right? Because it's so tedious, and you know, it could lose its impact if it's too much. But at common law, you have to do that foundation. The rules, the federal rules of evidence, however, most notably, Rule 613 did away with the requirement of laying a foundation, right? So it could be something as simple as, on direct examination, you said that the Cadillac had the red light, right? Isn't it true that in your deposition you said the Cadillac had the, whatever the color is, green or whatever? You understand what I'm saying? So it does away with that elaborate, elongated, foundational series of questions that would be required at common law. And most of you are going to be operating under either the federal rules or the state corollary to the federal rules that mirror Rule 613, which does away with the common law foundation requirement. However, and this is a big however, just because the federal rules allow that sort of minimalist approach doesn't necessarily mean, from a tactical standpoint, that you should always be that brief, right? Again, just to contrast the two, at common law, I'm showing you what has been marked as Defense Exhibit 1 for identification. This is the letter you sent to your insurer, isn't it? Yes. You wrote that letter 2 days after the attack and robbery, correct? Yes. You were at home when you wrote it? Yes. This letter was intended to notify the insurance company because you wanted to file a claim for the items that were taken from you, stolen from you. Is that right? Yes. Now, in direct examination, you said the attacker was a small man, didn't you? Yes. Your letter to the insurance company, however, says, I was robbed when this large man attacked me. Okay? That's the common law approach. Under the federal rules, you can ask two questions. On direct examination, you said the attacker was a small man, right? Yes. Isn't it true you wrote a letter to your insurance agent in which you said, I was robbed when this large man attacked me, right? So one extreme to the other. You see the difference there. Now, as I said, common law, much more elaborate, laying the foundation. Federal rules, you don't have to do that. All you got to do is give the witness the opportunity to admit or deny it, right? Or explain any inconsistency. That's the only prerequisite. And in that abbreviated form, you're giving him the opportunity. A less abbreviated form, but still abbreviated under the federal rules, would be, on direct examination, you said the attacker was a small man. Answer, yes. Did you ever make a contrary statement? No. Now you can impeach, right? Isn't it true that you wrote a letter to the insurance company where you said a large man attacked you? Okay? So that's giving them the opportunity to come clean. Now, if they come clean and admit, yeah, you're right, I said it was a large man. When you ask, did you ever give a contrary statement? Oh, yeah, I did in my statement to the investigator. I said it was a large man. Busted, right? One, being pejorative, just make sure you stay awake. So you understand, you got to give them the opportunity to come clean under the federal rules. If they come clean, great. No need to further impeach, right? If they say, no, my story, that's my story with small man, I'm sticking to it, then okay, let's do it the hard way. Remember your deposition? Direct your attention to page such and such, line such and such. Read along with me. You know, okay, I'll give you more specifics on exactly how to do that. But right now, I just wanted to contrast the common law, long way, and the minimalist federal approach under Rule 613, right? Now, as I said earlier, just because you don't have to do it the long way doesn't necessarily mean in every impeachment you may not choose to do some version, some in-between version. And why do I say that? Because when you go back to the common law requirements, they are there to establish indicia of reliability, right? That's why they're making you go square around the corner and laying the foundation to show that this prior statement is trustworthy. Indeed, it is more trustworthy than what they just said on the stand because it was given under these circumstances. It was given in a time that was closer to the event. You know, it was a day or two after the accident as opposed to 2 or 3 years. So it is more reliable than a lie you just heard on direct examination. Okay? So there is some benefit to that. So what I wanted to suggest, and just remember, this is just one way to do it. You know, LeBay may have different suggestions, ways to do it. Maui will have different, a different series of questions. It doesn't really matter necessarily the order in which you ask these questions, but I do think if you can minimize the steps in your head, it'll be easier. And if you adopt one particular approach, it'll be easier to summon that each and every time. And this is the framework that I think makes a lot of sense, or at least it works. I think it works well. I'll tell you why. Okay, so we're talking about impeachment by a prior inconsistent statement. And if you can commit this to some sort of memory, it'll become automatic for you. Okay, so think about this. Identify the statement to be impeached. Now I'm going to exaggerate a little bit with the inflection of my voice to make my point. Right? You want to let the jury know what it is you're doing. You want to let because when he says the Cadillac had the green light, the jury may, it may not matter to them. They don't know that that is a material untruth, right? So identifying the statement to be impeached, in addition to giving them the opportunity to come clean, as a prerequisite, the opportunity to come clean. In addition to that, it's telling the jury, listen up, folks. Did you just hear what this person said? I'm about to show you why he's a bald-faced liar. Now, I'm exaggerating, okay? But identifying this, did you, Mr. Parker, on direct, did you just testify that you only had a wine spritzer? Okay? That's identifying the statement to be impeached. Now, he's got a lot you can impeach him on. Jackie has two, not quite as much, but he's got quite a lot, I think. And again, just from that email. So identifying the statement to be impeached puts the jury on alert that something important is about to happen, and it goes to credibility. So you could do it with an inflection, you can do it with just emphasis in the way you're saying it, or you could do it in a non-plus way if you want to, because you don't want to signal to the witness that I'm about to slam you. That's another tactical decision. I prefer to, kind of call it out. I don't care if he knows he's about to get hit if I know that I've got a pretty big hammer and I'm going to hit and I'm not going to miss. I don't care if he kind of anticipates it's coming. So I'm going to say, now, did I hear you right? Are you telling this jury that you only had a wine spritzer? Okay, the jury is going to say, something's about to go down here, right? So that's why I like this order. I like to start with identifying the statement to be impeached. The second step is confronting with the possibility of an inconsistency. This is under the federal rule, Rule 613, where you have to give them a chance to admit or deny or explain the inconsistency. And it could be something specific, in which case you may hint to him where you're going. You know, didn't you in your email say that you had something different to drink? So that's going to alert him that it's the email you. But you can fulfill the requirement of 613 by simply saying, didn't you make a contrary statement as to what you had to drink on a previous occasion? That is, on a previous occasion, you said you had something different to drink, didn't you? That's not telling him where you're going. He doesn't know you're going to his email, right? So you have a chance to kind of get his proverbial stuff together and sort of explain away what's in that email. Oh, I was just referring to martinis general. I wasn't talking about having a martini that day, right? So if you want to retain the element of surprise, you're going to say something general. Go back to our traffic light example. You know, the driver or the witness to the accident says on the stand, the Cadillac had the green light. But in his deposition, he said the Cadillac had the red light, right? So if he says, and you're questioning that witness, then this is not a party witness, not an opponent witness, but just a witness, but an important witness, the witness to the accident. It's, you know, Mr. Jones on direct, and so this is where your tone is going to come in, because it's not a hostile witness, right? Mr. Jones, you just said on direct examination that the Cadillac had the green light. Did I hear that correctly? Yes, I did. Did you ever make a statement on another occasion that the light was a different color from what you said on direct, or something to that effect, right? The idea is that you're confronting with the possibility of inconsistency. So you give them a chance to come clean. Oh, you're right, I did say before, and that is the right answer. Your impeachment is over, right? But if they say, no, if Parker says, no, I had a wine spritzer, no question about it, you go on to your impeachment. So then, this is, number 3 is where the old common law foundation can be useful. Why? Because it shows reliability of it. Because you got 2 competing statements, right? One says X and the other says Y. Which one is to be believed? Well, you want the prior statement to be believed because it was given under circumstances that make it more trustworthy. So show why the inconsistent statement is reliable. You know, now this is where you got to be tactical. You may not want to, if you're using a deposition, to go through that whole rigmarole of, you remember giving a deposition in my office. You remember showing up with your lawyer that represented you. You remember taking an oath to tell the truth, the whole truth, and nothing but the truth. That's the same oath you took today, isn't it? You remember me asking you questions during that deposition. And you answered those questions truthfully, didn't you? And then you were given a transcript of your answers, and you were given the opportunity to review them, right? And you took the time to review them. And then you signed that deposition transcript as accurate, didn't you? But you go through all of that, and it's like, the jurors are getting cross-eyed. The judge is going through the roof because it's like, oh, please. Why are you, yes, it might have some probative value, and yes, at common law. We're not at common law. We're in the federal rules. Counselor, you don't have to do that. Why do you think the federal rules did away with all that nonsense? Again, I'm being pejorative to make the point. But maybe some indicia of reliability will dictate that you go through some of that. You gave a sworn deposition regarding the events in this case, didn't you? Let me show you your deposition, or let me direct your attention to your deposition, page such and such, line such and such. And then you impeach by reading from the exhibit. You read from the exhibit. Don't let them read, right? If it's, page 28, line 5. Tell me if I'm reading this correctly. Question: who had the red light? Answer: the Cadillac had the red light. I read that correctly, haven't I, Mr. Jones? And that's it. That's your impeachment. But you're reading. Same thing with an omission. If it's a police officer with an investigation of a car accident scene, they're showing you your report. Where in your report, or there's nothing in your report that mentions anything about the smell of alcohol, is there? Okay? But you control that whole demonstration, right? You never turn it over to the witness to give them a chance to look at it, think about it, to try to wiggle explanation around the obvious inconsistency. You read it, get maximum impact because the words don't lie, they are the words. No contextual manipulation, no explanatory. It's just, this is your testimony, isn't it? That's your deposition, your sworn deposition. Okay, so are you with me on how much you may want to do with showing why the inconsistent statement is reliable? And it doesn't have to be a deposition. It could be, a memo to file. It could be a letter. It could be, a statement given to the insurance company. But each of those different forms of prior written inconsistent statements will have some indicia of reliability to show why that inconsistent statement is reliable, as opposed to what they just testified to. And then, fourth step is impeaching by reading from the exhibit. All right? So, let's go back to these other forms of impeachment. Impeachment by oral statement, prior oral inconsistent statement is going to be similar to impeachment by written statement, except that obviously there's no need to show a writing to the witness. But some things you should consider or keep in mind before impeaching someone with a witness with a prior unrecorded oral statement. You, as a cross-examiner, should be certain that the party who heard that prior statement is reliable and has good recollection of the content of that. So if you're going to say you told the insurance investigator it was a large man, you better be sure you can get that investigator who may have heard that to reliably recount, because you're going to have to put that investigator on to corroborate that oral inconsistency. But just to give you an example of that, let's assume it's a victim who's testifying in a criminal assault and robbery case, involving this statement to the insurance company. So if it's an oral prior inconsistent statement, the question would be, now on direct examination, you said the attacker was a small man, didn't you? Yes. You spoke to your insurance agent 2 days after the attack and the robbery. Isn't that right? Yes. And you were at home when the agent came by. Yes. This meeting was to tell the agent and the insurance company about that incident because you intended to file a claim for the items that were stolen from you. Is that right? Yes. Now, you told the insurance agent, however, that he was a, quote, large man, didn't you? Yes. So that's just an example of impeachment by a prior oral statement. Now, we've kind of talked about the impeachment by prior inconsistent deposition statement. That's going to be the one that you probably use more often than any of these others, because depositions are just, it's a fact of litigation life, and it's a very important component to trial preparation and adducing the evidence you need to support your claims and defenses, and to undercut the other side's claims and defenses. So be ready, right? For every witness that you cross-examine, they have 2 copies of the deposition transcript, right? And you put 1 copy on the stand, right? That does a couple of things. It tells them, don't you go lying now. You're going to either be very embarrassed or I'm going to catch you. Because this is the Bible right here, just put it on the stand, with court permission and indication of what it is and what you're doing and all that good stuff. So you're always going to have 2 copies of the deposition for every witness that you cross-examine. And, if the witness is impeached, from that deposition transcript, you don't have to take the extra time to walk over and give him a copy and stand over him or her and read. That's, that's cumbersome, it's awkward, and, it could look a little bit harassing and intimidating. Just say, let me, please turn in your deposition, pay such line, such and such. and then impeach from the deposition transcript. And you may have multiple instances from the transcript, which makes this technique even more valuable, right? You don't have to keep going, approaching back and forth every time. If you caught him in 3 or 4 lies, or 5 or 6 or 10, you say, okay, now let's turn the page, blankety blank, line such such. You know, now let's turn the page such and. If you got that situation, you're in good shape, because now you've got a collection of lies, and you know, if you impeach him successfully on all those using his own sworn testimony, that's a good day for you as a cross-examiner. So, by the way, you don't have to impeach every impeachable statement. Use some discretion and only impeach where it really counts. Okay, so let's talk about some of these other less frequently occurring bases for impeachment. Let me just make sure we're okay on time. Yeah, we're doing all right. So, impeachment by bias, corrupt motive, prejudice, or interest. Rather obvious, each of these. Bias suggests that the witness is predisposed to a party, for example, based on loyalty as a friend or a family member or an employer. But it could be any fact that aligns the witness as a partisan to the person being impeached, right? Prejudice suggests that they're predisposed against a party. For example, if someone has had a fight with the party and he's a witness, so his testimony is prejudiced because of that prior encounter. So that might go something like, Mr. Jones, you went to the Saints-Cowboys game on September 29th of this year, is that right? I'm not quite sure, I don't remember. Well, you went to a game in September in which my client was present, did you? Yeah, and that was the Cowboys game, correct? Yeah. And you had an argument with my client, didn't you? Yeah. In fact, you and my client actually hit each other, didn't you? Okay? So that would be an example of, actually that's probably more corrupt motive than it is prejudice. But you get the idea. I guess it could be either or. But that's an example of how you would talk about prejudice or corrupt motive in the context of impeachment. Now, if the improper motive doesn't involve a specific event, like that, in that case, a fight, you could raise the improper influence in general. For example, Mrs. Jones, you're the defendant's mother, aren't you? Yes. Okay? That's just another example of impeachment by prejudice. Corrupt motives, for example, a bribe, or a negotiation and a plea agreement where, the plea is contingent upon them testifying in another case, something like that. And so you get the idea. There is some, or interest in the outcome, of the case. For example, they have some financial interest in how, the case turns out. Could be an heir who was not, who is contesting the validity of the will because they were not given a bequest, right? So they have an interest in the outcome of that proceeding resulting in the invalidity of the will, right? Now, impeachment by prior criminal convictions, there are two categories for that. One is if it's a felony or a misdemeanor that involves some sort of dishonesty or false statement. Doesn't matter if it's a felony or a misdemeanor. You can impeach with that. And the other category, if it's a felony conviction. You all covered that yet in evidence under Rule 609? Have you all gotten to 609 yet? No? How far have you gotten? What rule are you on? What's that? Okay. All right. So, for a prior criminal conviction, let's say Kim Anderson. Are you the same Kim Anderson convicted of a felony in May of 2015? Yes. That felony was for income tax evasion. Was it? Yes. And you were sentenced to 2 years, weren't you? Yes. And you served 10 months in prison for that, didn't you? Okay? So that's an example of impeachment by criminal conviction. Is it time? Are we up yet? Oh, I'm so sorry. Well, impeachment by prior by bad act. Ms. Harris, isn't it true that you were recently fired from your job? That was because you had lied on your application for employment, wasn't it? Okay. So if it's a prior bad act, you know, obviously it's got to fall short of a conviction, because if it's a conviction, then you go to Rule 609. Yeah.
So on Monday, who were we?
That's what I wanted to say. Find an impeachable moment in the file.
Just like anyone?
Well, it can be anyone, but try to focus on the parties. Andrew Parker, I can tell you that that email that I was referring to it's got a bunch of stuff in it, right? Exhibit 33, his email, got all kind of stuff in here. I don't want to give it away. Find it, okay? You know what he's going to testify to on direct. For Jackie, I think Jackie's, dateme.com profile has some stuff in it. But there's other material in the file. It could be any witness that, and what you're going to do is you're going to tell the adjuncts, I'm going to impeach this witness on this testimony, right? So they're going to assume that the witness has testified, such and such. So even if you have to fudge the facts, as long as it's within the universe of facts in the file, this is just to illustrate technique, not skewing the facts one way or another to win. You understand what I'm saying? So try to limit, I would try to do it with Jackie if you're representing the defendant, and I would try to do it with Andrew Parker if you're representing the plaintiff. You got lots to work with there.
Right, so we don't have to do any, there's like impeachment problems in this book, so we're not doing those.
Oh, they are?
Yeah.
Oh, that's even better. Hey, if you've got problems, you mean in the case file?
I mean, they're just like assuming that someone did something that's.
Well, there you go. That's an even better. I didn't see it. You can. It's all fair game, I guess is what I'm saying. Find something that is impeachable.
It doesn't matter.
It doesn't matter.
Okay.
All you do is you tell the adjunct, this is what I'm going to try to impeach this witness on. A warm body will be put up there, and the warm body will just go along with, yes, that's what I testified to on the record.
Okay.
Take your best shot.
We have no idea, because a lot of us initiated.
Well,